Okay, I'm going to explain the Parol Evidence Rule. The Parol Evidence Rule is a rule which determines whether terms in writing are to be included in the agreement. Should the written evidence be used as a source of the terms of the agreement? There are two versions of the rule: the modern approach and the traditional approach. The traditional approach states that a written agreement appears on its face to be a complete agreement. The parole evidence cannot be used to contradict, vary, add to, or subtract from the terms of the agreement. Page 195. The parole evidence, the traditional parole evidence rule prevents a party to a contract from later adding a term previously or concurrently agreed upon, but that is not included in the final contract. It is meant to preserve the integrity of the contract. Before the agreement contract is complete, there is a bargaining process in which terms are being negotiated orally or in writing. Once the terms have been agreed, the agreement is written and signed by both parties. It could be possible that one of the terms previously agreed has been omitted from the master contract by mistake, perhaps a typing error. The parole evidence rule is there to protect the terms of the contract. However, this traditional parole evidence has been criticized for its unjust outcome. Two decisions of from the Supreme Court of Canada took the traditional parole evidence stance. First one is Harish versus Montreal Bank, and second is Bauer versus Montreal Bank. Both cases concern the enforcement of a bank guarantee. The modern approach focuses on the need to demonstrate that the parties actually intend to reduce their agreement in writing as a precondition to the application of the rule. Page 195. The modern approach allows prior communication of relevant to the case to be admissible. This would mean that the prior written communication is a valid form of exclusive source of the agreement. There is no remedy to the contract, and the parties are held accountable when there is no evidence that the terms were omitted. The parole evidence rule will prevent parties from adding terms previously agreed upon between parties but which are not written in the final contract. The rule does not exclude evidence supporting the agreement, right? If the terms of the contract is incomplete or obscured in its meaning, the parole evidence may be used to make clear the meaning of the terms. The evidence can also be used to identify one of the parties to the agreement. Okay. Is it a complete bar to oral testimony? How do courts get around it? Well, no, it is not a complete bar to oral testimony. The court have indicated that evidence of the collateral oral agreement is admissible only if the agreement is not in any way inconsistent with or contradictory to the written agreement. In the case Harish, the agreement was inconsistent with the provision in the guarantee. The guarantee was a continuing type. The court got around this bar to oral testimony by ensuring that oral agreement is not contradicting the agreement. There must be no inconsistency with any of the terms of the written agreement.